Carbone, the general counsel of that agency. This appeal is from a final order issued
Excuse me,
by...
Counsel, do you want to reserve any time for rebuttal?
Oh, thank you. I'll plan to reserve 5 minutes. I have a lot to go through, so time scheduling is important to me here today. It's an appeal from a final order of an administrative law judge declaring certain rules, both proposed and adopted, of the Department of Elder Affairs were invalid. Two of the petitions, there were 3 petitions, they were consolidated. 2 of the petitions were challenged as opposing proposed rules of the Department of Elder Affairs. It's our position that those 2 petitions were untimely filed and that the administrative law judge had no jurisdiction to
Well, Counsel, let me
entertain.
ask you a question about that then.
Please.
Suppose we completely agree with you with regard to, this just hypothetical, we completely agree with you with regard to the challenges of the proposed rules because they were not timely. I've seen the 3rd petition. It seems to challenge exactly the same thing. It's challenging existing rules, which does not have the same time limitation. Why can we not do this entire case? If we found that those 2 petitions were untimely, why could we not just base this entire case on
Well,
the
there's
3rd petition?
several reasons for that. One is, being a jurisdictional question, you have to determine whether the administrative law judge was correct regarding those 2 petitions. Secondly, one of those petitioners, FALA, considers itself to be a prevailing party and has filed a motion for attorney's fees with the administrative law judge. Under the statute, anytime a party succeeds in a rule challenge proceeding, they are entitled to attorney's fees. So
So on the fee issue, but I mean, you're not suggesting that we could resolve the whole case on the timeliness?
Oh, no.
Okay.
No, the petition that challenged the rules as existing rules
The
was timely
FSLA
filed.
petition, okay.
Yes, there's no deadline for that. And very quickly, on the question of the timeliness, the statutes are very clear. You have to file your petition on a challenge to a proposed rule within 21 days after notice in the Florida Administrative Register, which date occurred on March 5, 2018. The actual petitions filed were almost 60 days after that, so clearly beyond that deadline. The administrative law judge found a saving grace in that the fact that one of the rules noticed was not modified, it was withdrawn. And the statute on timeliness on a proposed rule says, if a statute or a proposed rule is amended, you can have 21 days to file your challenge, but only if that proposed change increased the regulatory burden upon yourself. That clearly did not happen here. The rule that was originally proposed was never challenged in this proceeding, by the way, before or after, but it happened to be changed by the department.
So if it did increase regulatory burden on the licensees, then they could raise this challenge to all of the rules?
Not all of the rules,
Okay.
no. The statute's very clear. Only to the rules subject to the change. The administrative law judge ignored that and let the challenge to all the rules be proceeded as proposed rules. That was clearly wrong because they're all separate rules and it just should not have occurred. And the judge in his own order recognized, citing the Alice P. case, it's a jurisdictional matter. But nevertheless, the statute was not applied as written. The question about whether the change to the rule created any additional regulatory requirements was overlooked, when in fact the only change that occurred was a withdrawal of a regulatory requirement. Not to dwell too much on this, but the rule as originally proposed would increase the record-keeping requirements for an ALF, not just for permanent residents, but those who spent a few hours there during the day. After the department thought that over, it decided to withdraw that record-keeping requirement. So clearly, there was no additional burden caused by this amendment to the rule, and these proposed rule challenges should not have been allowed. I'm going to then go on to my next issue. I have several in this appeal. The judge, I'm going to go through the individual rules that were invalidated because that original argument doesn't talk about an individual rule, it's a procedural issue. The definition of unscheduled service need was one of the rules, And it states that it's a need for personal service, nursing service, or mental health intervention that cannot be predicted in advance and must be met promptly to ensure the health, safety, and welfare of residents is preserved. Sounds pretty innocuous. The administrative law judge found this rule to be invalid because he said it was vague. I can't find anything vague about that rule. But vagueness he conditioned on his finding that the rule was not merely a definition, but also included a duty. Now, there is no case or a statute that declares a rule invalid merely because it may be a definition that could also involve a duty.
Well, counsel, just so I understand, it is a definition. It defines what unscheduled service need is.
Right.
It does so in a way that sort of implies that there's a duty on the part of an employee to do something. But is there a rule that you could impose on the licensee if you found that an employee did not perform what was necessary for an unscheduled service need as defined?
I think the answer to that is overwhelmingly yes.
Under
Because
what?
the rule does not actually...
Under this definition?
No, under the entire statutory scheme. If you look at the entire statutory scheme of this chapter, one thing is very clear. People who run assisted living facilities have a continuing duty to watch out for the health, safety, and welfare of their residents, who by definition need assistance with living, under the statutory definition. So all the rule says is that if something comes up that's unscheduled, you must respond to it promptly in order to protect the health, safety, and welfare of the resident.
I don't want to, look at this too finely, but it doesn't say that they have to do that. What it does is define unscheduled service need.
That's all it does.
So my question is, what if an employee of an ALF violated this, did not promptly ensure the preservation of a resident? How exactly would you charge the ALF?
That would be coming from another part of these rules.
Can
This
you
rule,
identify the part
you
of the
could
rule?
never be charged
Sure.
with violating this. It's merely a definition.
Can you identify the rule that you would charge somebody with if they violated that?
Well, there's a host of rules, and a lot of them not subject to this proceeding. What you only see in this record here is snippets from the entire rule chapter, but it's quite definite. One of the primary responsibilities of an assisted living facility is to protect the residents from neglect and abuse. I mean, that's why they're there. That's why, and I want to get into the statutory rulemaking authority imposed upon the agency, which is extreme and extensive. Legislative intent is very clear from this chapter. The department is tasked with the responsibility of adopting as many rules as are necessary to make sure residents are protected from neglect and abuse or suffer or from contact with unsanitary conditions, the transfer of pathogens. This duty is the primary duty an ALF has to protect its residents.
Mr. Ortell, these rules are laced with words that aren't self-defining, I suppose, but promptly, for example, isn't that context-driven?
Promptly
What
to
is
me-
prompt for somebody's having a heart attack, prompt action may be one thing, somebody's having indigestion, prompt action may be another thing.
Absolutely, and that's why the word promptly means as soon as necessary. Unscheduled service need could include something as a resident wants another shower a week. Well, that's not an emergency, but it has to be attended to, not immediately, maybe in a few days, but you're absolutely right. The incident that may fall under this definition could vary from a medical emergency that needs immediate attention to something as trivial as a different meal menu. So the word promptly in the context clearly means as soon as necessary, or sooner is reasonable. I mean, it seems self-evident to me. I would like to move on to some of the other rules because I perhaps have more on my agenda than time allows. I want to talk a bit about the statutory authority of the department to adopt rules, and it's extremely extensive. It's mostly in section 429.41. I plan to go through it quickly with you, but This is about the most extensive grant of rulemaking authority I've seen in a statute delegating such powers to a state agency. And the important thing about the delegation of powers in this case, other agency statutes say the agency may adopt rules to carry out these sections and may adopt things on these subjects. That's discretionary with the agency. This statute is very clear that the department must adopt rules that cover a host of subjects. It's about 5 pages long. And it includes providing a reasonable and consistent quality of care in a safe and sanitary environment where the department shall adopt rules which must include reasonable and fair minimum standards to a host of issues. And I want to highlight some of them because they are reflected in the administrative law judge's final order, which we think is totally unsupportable. Among the things the department must adopt rules for are resident elopement requirements, sanitary conditions within the facility that will ensure the health and comfort of residents, the enforcement of the Residents' Bill of Rights, which is a separate statute, 429.28, and has a host of things that residents are entitled to get from a facility. Resident records, internal risk management, the establishment of specific criteria to define appropriateness for resident admission, policies and procedures on resident elopement. All those are issues that are relevant to the administrative law judge's final order. And briefly, see that time is not my friend here. One of the things that the judge found to be invalid was medical examination of a potential of a resident on a form, ECA Form 1823. The statute in question requires, upon admission, that a resident be examined by a medical health professional on a form provided by the agency, AHCA, AHCA. Administrative law judge said there's no statutory authority for the use of this form. It's exactly in the statute. And the rulemaking authority of the department, as I just read to you, is the establishment of specific criteria to define appropriateness of admission. Now, the judge found this form to be totally, almost exclusively invalid, and he pointed to not having enough statutory authority, being inherently unreliable. The form is a requirement of the statute. The only requirement the statute says is that a licensed medical practitioner must fill out a form, which we did, and every question on that form, according to the petitioner's own witnesses, is relevant to the question of whether a person is suitable to be a resident of an ALF. So we have a form that's required by statute. We have statutory authority to devise standards for admission. And we have a form where their own witnesses said every question is relevant. The only criticism, not of the form, but of the process, is that often the medical practitioner filling out the form may not be very familiar with the resident. That's true, but that's all the statute requires. The administrative law judge is finding that this form was invalid because he called it inherently unreliable is a function of the statute. The agency cannot, by statute, we can't add any requirement to the law. For example, the department couldn't adopt a rule that says, by the way, this medical practitioner must be very familiar with the resident. That would be amending the statute. That would be contrary to Chapter 120 because a rule can never modify, amend, or add to a statute. So, like it or not, we're stuck with the statute. What the administrative law judge found on this form was he just didn't agree with the process. But right or wrong, if his criticism is valid, it's a function of the statute. It's not caused by the rule. Now, some of the other rules that are at issue in this case and becoming apparent, I mean, I have to rely on my brief for some of these that I can't address. He found that the rule on elopement standards. Now, elopement is a serious situation. Elopement means a resident wanders off premises, may have some cognitive issues, goes out on the street, and gets into a dangerous situation. The statute says the
Mr.
department
Ortell,
must...
talk to me about this generally aware standard.
Yeah, okay.
That struck me as being
Well,
somewhat nebulous.
genuinely aware clearly means keeping track of. One of the petitioner's own witnesses specializes in evaluating elopement risk of residents. She testified as to how that risk can be assessed. She also testified that keeping track of residents who you've identified as being at risk for elopement is a very good idea. And to me, being generally aware of the location of somebody you've already identified as subject to wandering means just that. You don't, and some facilities will attach a GPS monitor. That's voluntary, though. You either are...
But generally aware sounds like a low standard. That to me sounds like, well, I knew he was somewhere in the building. Or
It may be.
I thought he was in the cafeteria an hour ago.
As I
you
mentioned
know.
in the brief, it's between being fully aware by constant surveillance or totally indifferent to where that resident may be. It's to keep a conscious effort to every so often say, okay, Mr. Brown's here, he's having lunch here, and he's here, and just in your daily activity, try to keep track of where persons at risk are so they don't leave the facilities and wander out in the street or go to the corner tavern, which is not something I made up. It does happen. These are
But how do you
rules.
enforce that? Because one facility's definition of that may be different than another facility's definition.
I don't know how
If you're a
else-
good lawyer and you're advising them, I guess you tell them what generally aware must mean in a liability context, you know? You gotta know where these people are.
You're right, but there is a responsibility to keep track, and frankly, I don't know how else you could better describe it, except to say constantly under total 24-hour surveillance. And that's something the department clearly decided it chose not to do. I apparently have less than 3 minutes left.
I think I stole a few from you, so.
Pardon?
I think I may have stolen a couple from you.
Well, I'll take that as a grant of more time.
That'd be up to you.
Another rule, and this is an important one. Rules say the facility must have a protocol for infection control, which must include a requirement that staff wash their hands after each resident contact. That's a direct quotation from the Center for Disease Control. And and the judge recognized that hand washing is probably the most effective way to control the spread of pathogens and infections. And in the documents we introduced into evidence in this case without objection, there's a document from the Center for Disease Control that categorizes the risk of infection in nursing homes and
So my understanding of the objection wasn't that a requirement for hand washing is necessarily a bad thing. It's that every contact was vague. This is the way I read the
Right.
ALJ's report.
But he
So can you
also-
address that specifically?
the judge said he found this proposed rule, this rule to be facially invalid. There's no testimony. All his comments are his own self-described impressions of the testimony. He also said it's sensible, it will reduce the effect of spread of pathogens, and well, there's 5 or 6 documents in the record here from different publications, including the CDC, which use that exact language. After every resident contact, you must wash your hands. And the other document we put in the record, our Exhibit 11, categorizes in assisted and nursing home facilities how many, 380,000 people a year are chronicled to die of infections in these facilities. And these infections are transmitted mostly by human contact. So yes, the rule may be, you can call it severe, but it's within the department's discretion to decide how much protection residents of ALFs are entitled to. And an administrative law judge on his own can't call it facially invalid because he would have preferred, I guess, a less strict standard. That's not his job. His job is to look at the evidence, apply the correct law, and come with a decision. He didn't do that in this case. He acted as if he was the superior expert witness, because to call this rule facially invalid, the only testimony regarding this rule from the petitioner's witnesses, who's a physician, was that the rule made a whole lot of sense, that hand washing was the most effective way to combat the spread of pathogens. In his own words, he called the rule unnecessary. Well, that's not his call. The department believes it is necessary. And
Counsel,
it will-
you've gone
I've gone.
past your 20 minutes. I can give you 2 minutes to respond quickly to
That would be fine.
these assertions.
For the rest of my arguments, I didn't address, of course, relying on my briefs.
Absolutely.
Thank you.
And could we please get 2 more minutes for
Thank you.
the appellees as well?
Thank you. May it please the court, I'm Amy Schrader for the Florida Senior Living Association. And just at the outset, I wanted to point out that Mr. Ortel has mischaracterized a number of items in the final order, and I hope to go through many of those for you. First, I just wanted to point out that, this was an interesting rule challenge. We had challenged 16 separate provisions of the rule chapter that had been amended, and we prevailed on 14 of those. The judge made telling findings saying that many, if not all of these, were not supported by the statutes that were cited. As Mr. Ortel explained, the department took the position that they have broad rulemaking authority, somehow harking back to the early 90s where there was the test, if it's somewhat related to your area, you can go ahead and make rules. Well, that's not the test that's applied. We apply the day cruise test, and we apply the flush left language of 0.52 sub 8, which says you have to have that specific rule authority. And for all of the ones that are at issue here, they simply don't have that rule authority, or there is no factual nexus that allows them to adopt that rule, and the judge ruled that it was an arbitrary or capricious rule. Mr. Gilroy is going to be addressing a couple of those rules. He is also going to be addressing the issue of timeliness. I did just want to point out at the outset, just to address something Mr. Ortel has said, the judge did not consider all of the rules to be proposed rules when he ruled on these, as Mr. Gilroy will explain. So that is not a proper statement. Also, I think it's important for the court to understand that assisted living facilities in Florida are residential in nature. They can't be lumped in with nursing homes, which are more in the nature of a healthcare facility. Assisted living facilities don't all have nurses. They don't all provide healthcare services to the residents. It just depends on what type of ALF it is. So that's why the ALF administrator has to look at that individual resident based upon what's in that medical exam, what do those residents and those families need to see if they can fulfill the needs of that resident before they're admitted. So it's not in the hands of a healthcare provider to determine if that particular person is appropriate to reside in that facility. Just to go into some of the specific rules that were addressed, the hand washing rule. Obviously, everyone understands hand washing is a great thing. They are required to have a hand hygiene program. The problem with this, which the court has picked up on, is that it was being required that they sanitize their hands before and after each resident contact. That obviously encompasses more than the type of contacts where you would need to sanitize hands, helping with medication, helping someone with a bandage, if we're preparing food. All of those are obvious things that are already covered under these hand hygiene programs. These are, we're doing bingo and we have someone high-fiving someone. We're touching Miss Wilson on the shoulder and saying, here you go, dear, let me help you to your seat.
Counsel, let me ask you a question. I'm used to vagueness challenges in the statutory context, which is a lot different. Generally, you have a set of facts, and you say that no reasonable person would know that if I perform this fact that I'd be violating the statute. You may not bring up hypothetical situations. Well, the statute could encompass this or could encompass that. It's whether your conduct, whether somebody who committed your conduct knows that it's violated by the statute. Now,
Correct.
This is different here, especially in the proposed rule situation. It's not technically proposed, but for these purposes, it's close enough. It seems to me that we don't have that. We don't have a specific situation where the agencies come up and said, well, you didn't comply with this rule. So it seems to me we have to have a lot. I'm not actually sure what the standard should be in judging what kind of hypothetical situations we're going to be addressing. Should we say, well, gosh, if they high-fived a resident, then it could implicate the statute? Or should we maybe apply it in a way to say that, well, reasonably, this is what it means, and that's enough, even if there may be some outliers where it doesn't appear that it might or might not. But reasonably, it's enough that any reasonable person could look at this and determine what is permitted and what isn't. And that's kind of the argument I'm getting from the department, is that a
Sure,
reasonable
sure.
person could know that it just means substantial contact, not brushing up against a resident, not high-fiving a resident. So
Right.
how do we analyze vagueness in this context?
Okay, I think we don't analyze it under the vagueness standard because there was found to be no vagueness in this rule. It said that they must sanitize their hands. So that's why the judge came down and said it would encompass even that casual contact. We had testimony from the agency representative, I believe it was Ms. Avery, stating that they didn't intend for it to encompass all of that contact. But she couldn't state how, you would figure that out. She just figured someone might sensibly interpret it, but the judge came down and just looked at the plain language on the face of the rule and said they don't have any discretion here. So it over encompasses, activities that would not implicate a sanitation issue. So that was the issue there with the hand
If they
sanitizer.
reworded that one to put some sort of, non-casual conduct or contact exception, would that not run a risk of them being challenged as vague? I mean, how would you write something that captured the obvious things and didn't capture what, maybe would fall under prosecutorial discretion or something like that?
Sure. I mean, I think you could probably refer to a certain protocol, certainly not the CDC that was referred to by Mr. Ortel. That applies to healthcare facilities. It's important to understand under federal law, you do have assisted living facilities that are treated as healthcare facilities. Florida, on the contrary, we have a requirement that it has to be a safe and sanitary environment that is residential and non-institutional in nature. And that's the other thing that this violates, is that if you have that hand sanitation before and after everything, that turns us into an institution, not these people's homes, where they should be feeling comfortable. If they require that higher level of care, they will no longer be allowed to reside in an ALF, and they have to be moved to a nursing home, which is an institutional, level of care.
How about the word significant? I mean, I get hung up on that. I mean, it does modify contact as a significant contact, but then what meaning are we to ascribe to significant? And is that a word that's used in other contexts where courts say that's an okay word?
Could you refer me to significant? I'm sorry, I'm not seeing it in the rule language that I have here.
Oh, that was an argument in, I think, your opponent's brief about reasonable interpretation would be significant contact.
Well, it's simply not what it says, It says before and after, there's no exception made for this. Why would you sanitize your hands before you high-five someone? You don't even know if you're going to high-five someone, We we had testimony that everyone understood that this would encompass this. You would hope that the person, wouldn't, fine them for this happening, but they put it in a rule, so they must have seen it as being important enough to enforce, and that's all that can be presumed.
Yeah, I beg your pardon. That was the argument, I believe, in
Oh,
the
okay.
brief, that the interpretation would encompass significant contact.
That would be great if that were in the rule, but it's simply not, and we're left with the rule language. So that's the problem, is that, our folks don't know how that's going to be enforced, because all you have is the language, not what, an individual agency employee might tell you they would like to interpret it as. 10 years down the line, those same agency employees won't be the ones interpreting this. So we're left solely with the language. If I could move forward, I think what you had discussed with Mr. Ortel, the unscheduled service need rule. We have cited in our brief that this was a definition only, it's not applied. We do have cases cited to that effect, such that it does seek to impose a duty. It also requires the ALF.
Well, why is that wrong? Why is it wrong for a definition to impose a duty? If assuming, and that's what I was trying to get
Sure.
with Mr. Ortel, was whether you could actually punish an ALF for violating this. Other than that, why can't you impose it? I mean, number one, it's not a change from what the rule was before.
It's a bit of a change.
Well, it is, but I think before it did impose a duty. So it's not even a change, but where is it stated that a definition can't establish what a duty is?
Well, there are cases cited in the final order that we've also cited to where that has been struck down when it's included in a statute. So generally, I understand your question. It is different. That was a new argument that I was unfamiliar with. We were more concerned with the fact that it was requiring the ALFs to take steps to address every service need promptly, and that was, not factually going to be necessary. Where if you're saying we need an extra shower in the week, not that we need a defibrillator because someone's having a heart attack. Obviously, you address them as need be, but the new rule language left a lot to be desired. We also found it to be vague, and we have testimony that supports that. The department representative, Ann Avery, said she had no idea why they changed this rule. They added the word ensure to it. They moved things around. She doesn't even know what the effect is supposed to be. So if the agency doesn't know what it is, it's very difficult to say that those that are charged with complying with that should know what it means.
Well, I seem to recall her saying that it appears that it just sort of streamlined the words,
Right.
made it a little less wordy.
Less wordy, right?
That was my first impression upon reading the amendment. I mean,
You're-
why can we not just say that, yeah, this appears exactly what it does? It doesn't actually make a substantial difference in the requirements of ALFs, it just changes the words of the rule.
Yeah, I mean, we have a different interpretation that it seems to require you to ensure that the needs addressed promptly instead of doing it in a reasonable amount of time to ensure that health, safety, and welfare is maintained. But that had been our argument. I want to kind of get through a couple more of these because there's some important ones I need to hit.
I had a quick question on the vagueness. Judge
Sure.
Winokur a minute ago talked about the difference, in the non-administrative context, how you look at vagueness, and in that context, obviously, we wouldn't be looking at testimony about what people think it means. It'd be kind of a legal issue. Is that different in this context, and is that clear? That it would be appropriate for the ALJ to consider testimony on a vagueness question?
Well, I think there is this, and I have it cited in our brief. Yes, if let's see. This is the Department of Financial Services Peter Brown construction case. It says if an administrative rule is invalid under section 125.28D, if it forbids or requires the performance of an act in terms that are so vague that persons of common intelligence must guess at its meaning and differ as to its application. So I think, that kind of goes to the fact that the agency employee wasn't quite sure what the meaning was or how it would be enforced. So if the agency itself can't enunciate that, then I think that does lend itself to the standard under that case, is finding it to be vague.
Thank you.
Okay, I want to move forward a little bit because we talked a lot about the Form 1823, and I'm going to roll that in with the assessment of elopement risk rule because there are some similarities there. The problem here is that the agency is asking a healthcare provider to do things that a healthcare provider is not probably qualified to do. And there were significant findings of fact made in the case. The ALJ, in looking at what was supposed to be under the medical examination that ALF residents have either immediately preceding or right after being admitted to the facility, was under the 1997 CMS guidelines. The department conceded in their proposed final order that these guidelines were appropriate and covered everything. They made a statement that they believed it covered nearly all of the items on the 1823 form. As you probably noticed in the final order, the judge significantly disagreed with that and determined that most, not most, and he didn't get rid of most of the form either. He left everything that was medical in it. He just said, I don't think that a healthcare provider who's never seen this patient before is going to be able to assess whether they're an elopement risk. We had testimony from a trainer who does elopement risk analysis and is well regarded that there are 30 factors going into elopement risk. Only one of those is a diagnosis of dementia, which is what the healthcare provider would be qualified, to do. So what the process is if the person has dementia, they get into the ALF. You have someone who's a member of the ALF, the administrator, or someone they hire as a specialist. They sit down with the family. They actually go through all of these behaviors and test them to see whether they're an elopement risk. The reason this is important is because if someone is an elopement risk and a doc just checks, out of an abundance of caution, that person has to go into a memory care facility, which can be extremely expensive for that family. So these are private pay. This is not like Medicare, Medicaid covered, services. These are things that they have to pay maybe an extra $900 to $1,000 more for a memory secured facility. So that is problematic when you have a doc who only looks at dementia and says dementia equals elopement, which it doesn't. It places these people into a much higher level of care, oftentimes inappropriately. But out of an abundance of caution, if you have that checked on the 1983 form, a facility, they feel uncomfortable taking these folks into regular ALF, even if they do their own assessment and don't find they have an elopement risk. And the 1823 form, he went down a number of these, and I know I'm taking Mr. Gilroy's time here, but I think you can see he compared, elopement risk, assessment of whether the person was a danger to themselves. These are things doctors don't know unless they have a personal, history or connection with this patient. Whether the needs can be met in an ALF. The doctor doesn't know what type of ALF the person wants to go to. That ALF may have a nurse on their staff. They may not. They may offer dialysis in-house if that person needs it. They may not. They don't know what that ALF has, so they wouldn't be qualified to make that type of assessment. Those are assessments that are made by the administrator looking at the healthcare provider's form as a tool. And I think it's especially telling that if they go to their own doctor and they have the healthcare exam done before they come in within that 60 days, they can use whatever form they want. Elder Affairs wants to tell you it makes a difference if they come in and they've been in that facility for one day, they have to use this long form, which they called in their brief a questionnaire. There's no authority whatsoever in these statutes for a questionnaire going into all of these items that are not items that a healthcare provider is qualified to assess. I'm going to pause now and leave the remainder of my time to Mr. Gilmore. Thank you.
Thank you, Counsel.
Thank you.
Good morning, Your Honors. May it please the Court. John Gilroy, representing Florida Assisted Living Association. And yes, we're trying to cover a lot of ground very briefly, but I think essentially I'm dealing with or addressing two of the proposed rules, 024 and 031, both the subject matter being third-party interactions. One of the rules requires that all ALFs seek and collect and retain the records of third parties, which is a very common practice. The record shows very common practice for virtually all ALFs, whether they're a small 6-bed, which there are hundreds of, or a larger institutional facility. With regard to statutory authority, the administrative law judge essentially found, as to both of these primary components of the rule package, that there is no sufficient statutory authority for either of those requirements and regulations. Mr. Ortel for the department references and cites to a broad grant of authority, and Section 429, 41 certainly represents a broad grant of authority initially. But the administrative law judge went further. He went looking for not the most specific, but some specific authority. And he went down through each of the subparts of 429, 41, 1H. Mr. Ortel referenced the two that the judge found closest potentially to providing authority had to do with resident records and quality assurance. And he found that neither of those sufficiently provides statutory authority. Fundamentally, in both cases, as to both rules, we are not talking about micromanaging the agency here. We're talking about, yes, the statute does provide a broad grant of authority to do things generally to make sure that services being provided in ALFs are done well. But as in the Save the Manatee case, I mean, essentially citing back to that and contending that it takes more than that. We know flush left language and Save the Manatee, and this court in Save the Manatee cited in its note, a case, Investment Corp of Palm Beach, I think it was Department of Health versus, and said, here's what we're talking about. In this whole juggling act between sufficient authority and specific, but not, you're not looking for specific enough, just specific. Okay, I think we get it, and I think you all captured it very well in saying, are we trying to micromanage the agency? And I would contend that as to 024 and 031 having to do with one being just collecting some records, which is in and of itself a whole departure from the whole regulatory framework. Recent case talked about, following United Faculty of Florida, talked about, well, there's a regulatory framework. And that language itself, first of all, the case had some unique aspects to it, but even if you look at regulatory framework, the framework in 429 and specifically 41 and the entire statute is the operations of the assisted living facility. Nowhere else in the statute is there provision for, and while you're at it, you need to be engaged, responsible for, or overseeing the operations of third-party providers who are separately licensed, nurses in some cases and others, who come in and provide services to a resident. And remember, an assisted living facility is just that person's residence. That's all. Not a healthcare facility. It's just like their home. And they're entitled to have, and in fact, the statute provides that family members are perfectly entitled to separately arrange for services to be provided without connection to the ALF. But I think it's important to just focus for a second, because we all did, on the word insure. Yes, the word insure is used in other places in the statute, in fact, in the regulatory authority. But the context is completely different. And if you look at the rule in 031 that says that the facility is responsible to cooperate with third-party providers, to coordinate to ensure that resident care is provided in a safe and consistent manner. Well, think about it. The only time that that is going to become an issue is when something has gone wrong. And there was testimony to that effect. Is effectively that's when it's going to come up. Well, once something goes wrong, the agency comes in and they would then assess, well, what did you, the assisted living facility, do to coordinate with this third-party nurse who had a problem? And essentially, was that coordination sufficient? Well, apparently and obviously not, because something went wrong. You didn't ensure safe and consistent treatment. And it really does. This rule goes beyond anything that the statute has provided for before. And it says, you're effectively, if you want to say coordinate, the judge said he thought it meant guarantee. Even if it didn't mean guarantee, even if it means to provide oversight, to manage, to somehow go behind the services being provided by a third party, and you, the ALF, being regulatorily responsible for the outcome. And that's just beyond any authority that exists in the statute.
Counsel, I think we're over time now already.
Fair enough. Thank you.
Briefly, Your Honors, the ALJ and the petitioners, the appellees here, are requesting a degree of specificity in rulemaking authority that this court has never required. And in our brief, we've cited a recent case of the Florida Supreme Court, the Goodman case, which clearly states that agencies, the rulemaking authority given to an agency doesn't have to be so specific that it covers every aspect of the possible rule. That would negate rulemaking and put the responsibility for the details on the legislature. And that's clearly not the standard or never has been. With the rule that Mr. Gilroy was talking about, requiring an agent, a facility to request records of a third-party nursing provider, the judge found that to be not irrational and that it promoted resident welfare. Well, the statute already gives the department the authority to adopt rules on records for a facility. And remember, we only regulate facilities. We don't regulate nurses. So we can't adopt a rule requiring a nurse to give a facility nursing records. And what the rule says is you try to get the records from a third-party nursing provider. The logic behind that is obvious. If a resident needs a medical intervention and has been treated by an outside nursing, how is the attending physician going to know what treatment or medication that person has been given? All this does, and the ALJ agreed, it promotes resident welfare. That's all these rules are supposed to do, promote resident welfare. With regard to the other rule Mr. Gilroy was talking about, if two nurses are providing assistance to the same resident, the rule requires them to coordinate. In other words, communicate as to who's doing what. And examples were given during the testimony where that has failed to occur. Residents have had to be taken to the emergency room. I mean, the logic behind this rule is obvious. If you're having medical people give treatment to the same resident, they should know what each of them is doing. Regarding that, the only other thing is, in response to your question, Mr. Winkler, there is no case that says a rule can't impose, a definition can't impose a duty. It's never been stated, and it's certainly not in the statute as far as the list of things that will make a rule invalid. Thank you very much.
Thank you. Thank you for your arguments. We will be in recess one last time this morning.
All rise.